Imagine you're just buying a bowl of soup that boldly promises right on the label that it's like heart healthy.
Right. Sounds great.
Yeah, but what if the manufacturer has actually quietly engineered it with enough sodium to actively raise your blood pressure?
That's a huge problem.
Exactly. Or imagine putting your life savings into a tech stock because their financial reports look absolutely spectacular,
Yeah, only to find out later that a computer algorithm legally lied to you,
right? And then the CEO's just sitting there claiming they had no idea.
which happens more than you'd think.
I mean, we navigate through the world operating on this massive baseline of trust. You assume the soup won't kill you,
Yeah,
and you assume the numbers on your screen represent actual money. But that trust isn't just some naturally occurring phenomenon.
not at all. It's heavily, heavily constructed.
It is a highly engineered, fiercely contested, invisible safety net.
And it's a net we only really notice when someone falls right through it.
Exactly.
I mean, the structure of that net, the actual legal threads holding the global economy together, that is what dictates almost every single financial move you make.
From buying a pack of gum to planning for retirement.
Precisely.
So we are jumping straight in. Our mission for today's deep dive is to synthesize this massive mountain of business law textbooks, walkthrough guides, and landmark legal case studies.
There's a lot of material to cover.
There is, and we want to understand the three critical pillars of this system: consumer protection, investor protection, and corporate governance.
And there is a very specific narrative arc to these pillars. We're going to start right at the ground level.
The everyday stuff.
Yeah, looking at the psychology of everyday purchases and how you are protected from being misled in the checkout aisle.
Right.
Then we'll scale up to the stock market, dissecting the hard math of what happens when you actually decide to invest your savings.
Which is where things get really intense.
Definitely. And finally, we will go behind closed corporate doors to see how the system attempts to, well, police itself at the highest levels of executive power.
So whether you are buying a can of soup, blocking a spam text, backing a Kickstarter, or putting money into a 401k, the laws we are unpacking today dictate exactly how those transactions happen.
Yeah, they rule everything.
Okay, let's unpack this. Before we look at how people lose millions in the stock market, we have to look at how they lose 20 bucks at the store.
The consumer battlefield.
Right, the consumer battlefield, specifically advertising and marketing. And this whole arena is overseen by the Federal Trade Commission, or the FTC.
Yeah, the FTC is essentially the bedrock of consumer protection in the United States.
Congress created it, right?
They did. They created it to regulate unfair and deceptive trade practices because, I mean, they recognize that a free market only actually works if the participants have accurate information.
If everyone's lying, the market breaks.
Exactly. And a most common and arguably the most complex arena for those practices is advertising.
But defining what makes an ad legally deceptive has to be incredibly nuanced, right?
Oh, it is. The entire legal framework revolves around this concept of the reasonable consumer.
The reasonable consumer.
Right. So deceptive advertising occurs when a reasonable consumer would be materially misled by an advertising claim.
I want to pause on that because distinguishing between a genuinely deceptive ad and just like standard marketing hype seems totally subjective.
It can definitely feel that way.
For instance, let's talk about the legal concept of puffery. Puffery is perfectly legal, right?
Yes, puffery is completely legal.
These are vague generalities or obvious exaggerations. Like if a local diner puts up a neon sign claiming they have the world's best cup of coffee.
Right. Nobody thinks that's a literal scientific fact.
Exactly. No reasonable consumer actually thinks a global governing body held a blind taste test and awarded this diner a gold medal. It's just puffery.
Yeah, it's just marketing.
But where exactly is the line? If puffery is just the equivalent of good lighting on a photo, where exactly does the law draw the line between a vague generality and a half-truth?
Well, what's fascinating here is that it comes down to the presence of verifiable, objective facts.
Okay, verifiable facts.
Yeah. The law doesn't necessarily protect us from our own gullibility regarding totally subjective claims like tastes great or looks amazing.
Sure.
But it fiercely demands transparency the exact moment a company introduces material facts.
What defines a half-truth thing?
So a half-truth is a statement that appears to be based on factual evidence, but it intentionally omits crucial contextual information.
So it leads you to the wrong conclusion.
Exactly, leading the consumer to a completely false conclusion while technically saying something true.
Which brings us back to that bowl of soup I mentioned at the top. The sources use this classic legal example involving Campbell's soup.
It's the perfect example. So years ago, Camels ran this massive marketing campaign highlighting that most of their soups were low in fat and cholesterol.
Okay.
And the overarching implication of the entire campaign was that these soups were a very heart-healthy dietary choice.
And strictly speaking, the core statement was factual true, right?
It was. If you measure the fat and cholesterol in a laboratory, the levels were indeed low.
So they weren't lying about the fat.
They weren't lying on the fat at all, but what they failed to disclose was that many of those exact same low-fat soups were incredibly high in sodium.
Oh, wow.
And in the medical community, high sodium is a major, well-documented risk factor for heart disease.
Right, which completely contradicts the heart-healthy vibe.
Exactly. So a reasonable consumer hearing low fat and seeing the heart-healthy messaging would be entirely misled about the overall nutritional value.
Because they left out a huge piece of the puzzle.
Right. A highly material fact, the massive sodium content, was strategically omitted to create a false impression. That crosses the line from harmless puffery into an illegal, deceptive half-truth.
It's basically the sin of omission. You are technically telling the truth about variable A while actively hiding variable B.
Knowing full well that variable B completely changes the context.
That is wild. And that manipulative psychology brings us to another classic deceptive practice that the FTC aggressively polices: the bait and switch.
Oh, the bait and switch.
I think everyone assumes they know what this is, right? Like a store advertises a cheap TV, you show up and they try to sell you an expensive TV.
That's the common understanding, yeah.
But, and I'm using a dating app analogy here, if the profile's the bait, and the reality is the switch isn't trying to upsell a customer, just like standard retail business, why is that illegal?
Well, upselling it itself is not illegal at all.
Okay.
The illegality of the bait and switch lies entirely in the intent behind the initial advertisement.
The intent.
Right. The FTC requires that if you advertise a product at a specific price, you must have a bona fide, genuine intention to actually sell that product under those exact terms.
You can't just lure people in.
Exactly. You cannot use a fictitious offer solely as bait to trap a consumer. And the law actually outlines 4 specific conditions that can trigger a bait and switch violation.
Okay, let's walk through a hypothetical to see how these 4 conditions actually work in practice. Let's say I'll see an ad for a $200 giant flat screen TV at a local electronics store.
Okay, a great deal.
Right, I drive all the way across town to buy it.
So condition 1 is simple refusal. You walk in, ask for the $200 TV, and the salesperson flat out refuses to show it to you.
They just say no.
Yeah, they might immediately redirect you to the $800 model, claiming the cheap one is garbage anyway. If they refuse to even demonstrate the advertised item, it's a violation.
Okay, what if they don't refuse, but they tell me they're totally sold out? Like, sorry, we only had 2 of them and they went fast, but hey, look at this other model.
That triggers condition 2, which is failing to have a reasonable quantity of the item in stock.
Ah, so they can't just stock one TE to justify the ad.
Exactly. You cannot run a massive full-page newspaper. Oh, hey there, what's up?
Could you speak on the SEC?
Oh yeah, let's hear it.
Could you fast forward and speak on the investor protections in regards to the SEC?
Absolutely, we can certainly pivot to investor protection now.
That is a fantastic interjection.
We were planning on transitioning to that next anyway, so let's jump right into the financial markets.
So circle back to that 4th condition of bait and switch later, but let's dive into the SEC.
Yeah, that's where the heart of investor protection lies.
Okay, let's unpack this. We are moving from the FTC protecting consumers to the U.S. Securities and Exchange Commission, the SEC of protecting investors.
And we really have to understand why the SEC exists in the first place.
Here's where it gets really interesting. It all traces back to the stock market crash of 1929.
Which was largely unregulated. People were engaging in risky practices like buying on margin.
They were only paying a small percentage of the stock's value and borrowing the rest, which fueled the Great Depression.
So the government realized it was time to regulate securities to restore public trust.
This led to the creation of the SEC, an independent... Oh yeah, go on.
So, can you define a security for me and how we test diagnostic?
Independent federal agency dedicated to protecting investors.
That is a fantastic question. Let's tackle the definition of a security right now, as it's the foundation of everything.
Absolutely. The legal definition is incredibly broad, but essentially, a security is an instrument.
Yeah, it's an instrument that evidences corporate ownership, like stock, or corporate debt, like bonds.
But the actual law, the U.S. Code, defines it much wider.
It covers notes, bonds, debentures, and these things called investment contracts.
If you're wondering, is this specific thing I'm buying a security, you need to run it through the diagnostic.
And the main diagnostic tool is what's known as the Howey test.
This test comes from a 1946 Supreme Court case, SEC v. W.J. Howey Co.
It's used to determine if a transaction qualifies as an investment contract, which is a type of security.
There are 4 key parts. 1, did the person invest money?
2, is it in a common enterprise?
3, is the person reasonably expecting a profit?
And 4, is that profit derived primarily or substantially from others' managerial efforts?
If all 4 of those conditions are met, then legally that, hey, yeah, what's up?
For the second condition, what is a common enterprise? Like, what is common enterprise?
That is a critical point on the Howey test.
A great clarification question.
When the Howey test refers to a common enterprise, it means horizontal commonality.
Horizontal commonality, okay.
Yes, it means the pooling of investor funds.
Ah, so your investment is tied to other people's investments.
Exactly. The success or failure of your investment is directly linked to the success or failure of the collective group.
So you're all in the same boat, financially speaking.
Precisely. All the investors are commonly affected by the promoter's efforts.
Like when you buy stock, you and millions of other shareholders are invested in that company's success.
That's right. That pooling of money into one venture, that shared fate, is the common enterprise the test looks for.
That makes the Howey test a really cohesive diagnostic.
It does. It ensures that companies can't just slap a different label.
Oh, back to our listener. What's up?
But does this have to be within the context of the stock market, or can it be outside of the stock market?
That is a phenomenal question.
And the simple answer is absolutely, it can be outside the stock market.
Okay, let's unpack this. The Howey test is used precisely because it's not limited to traditional stocks or bonds.
It's meant to capture those creative investment schemes,
Things like fractional undivided interests in oil, gas, or other mineral rights.
or even interest in limited partnerships and other investment schemes.
If the transaction meets those 4 conditions, it doesn't matter if it's traded on the...
Oh, go for it.
So does the security have to sell shares for?
Oh, go for it.
Is it as in, like, do they buy shares of it, or would they buy commodities of it, like pieces of it, the actual material which is secured?
That's a great follow-up question about the form the investment takes.
When we talk about these non-traditional securities, like the fractional interests you mentioned,
You generally aren't buying shares like traditional stock.
no, you are buying an actual fractional undivided interest in the
Ah, yeah, uh-huh.
But then these commodities would be managed by someone other than you. That's why it's considered.
Yep, go on.
It's managed by someone other than you. So, like, the commodity itself, it might be commodity itself, but then
Oh, yeah, uh-huh.
it needs to be managed separately for the expectation of profit. Like, it's investment.
Oh, yeah, uh-huh.
It's an investment of money to expect a reasonable profit. But this profit
Oh, yeah, uh-huh.
will be derived from others' efforts rather than yours in regards to,
Oh, yeah, let's hear it.
for example, this commodity that you wouldn't necessarily have any other thing in it except for
Oh, yeah, let's hear it.
investment, and that's what makes it a security.
Exactly. You are perfectly synthesizing the Howey test right there.
That is the crucial 4th prong. The profit must be derived primarily from the efforts of others.
That's why your question about commodities versus shares is so spot on.
If you buy a gold coin, it's a commodity, not a security, because you are responsible for its storage and sale.
But if you buy a fractional interest in an actively managed gold mining operation where experts are running the show and you just collect revenue, that meets the test.
You've invested money in a common enterprise, expecting profit derived from their managerial efforts.
That economic reality is what makes it a security, regardless of the label.
So going back to your example of oil rights, you're buying a piece of the right to the oil revenue.
You generally aren't buying traditional shares in the oil well company itself.
You are buying a piece of the underlying asset.
It's all... Oh, yeah. Go on.
So the Securities Act of 1933, did it only
Hey, yeah, what's up?
Did the Securities Act of 1993 only
Oh, back to our listener. What's
only
up?
did it create the SEC or did it create the laws in regards to initial offerings?
That's a great historical clarification.
It's a bit of both, actually.
The Securities Act of 1933 primarily created the laws governing those initial offers.
Yes, it was a one-time disclosure law.
Its whole purpose was to inform the investor.
Oh, go for it.
So was it an act that created the Securities and Exchange Commission? How was that? What kind of law created the SEC?
Oh, go for it.
Which act created the SEC?
That is a perfect question for clarity.
It's a subtle but really important distinction between the two acts.
The U.S. Securities and Exchange Commission, the SEC itself, was established by the passage of both the 1933 Act and the 1934 Act.
They were passed sequentially, and the SEC was a product of both.
But the core structure was laid out in the Securities Exchange Act of 1934.
Think of the 1933 Act as the one that created the initial rules for selling stock for the first time.
And the 1934 Act created the actual federal agency, the SEC, to enforce the rules and regulate the subsequent trading.
It's kind of a 1-2 punch of legislation.
Yeah, both were needed to restore.
Yeah.
So then, in the Securities Act of 1933, in regards to just the initial offerings, does the
Yep, go on.
registration statement only disclose and inform
Oh, yeah.
only disclose and inform the SEC in regards to their filing?
That is a very specific focus on the 1933 Act.
And you are correct. The 1933 Act is primarily concerned with that one-time disclosure.
Its requirement is the registration statement.
Okay, let's unpack this. The registration statement is the key mechanism for disclosure under the 1933 Act.
If a security is not exempt, it must be registered with the SMC before it's offered to the public.
And part of that process means the issuing corporation has to provide every investor with a prospectus.
The prospectus is essentially the disclosure document.
It describes the security being sold and all the risk involved in the investment.
This is how the SEC ensures that investors are fully informed about the initial sale.
So the company's disclosing everything to the SEC so the SEC can ensure.
Oh, yeah, uh-huh.
And what is the bypass lane or the well-known seasoned issuers?
That is a phenomenal question about one of the most interesting exemptions.
Yeah, that term, well-known seasoned issue, or WKSI, is definitely a mouthful.
And it essentially refers to a company that's so financially stable and has been around so long that the SEC gives them a shortcut.
They bypass a lot of the waiting period requirements.
Right. A company qualifies as a WKSI if they have issued at least $1 billion in securities over the last 3 years.
Or if their outstanding stock is valued at $700 million or more.
Because they're already well known and highly scrutinized by the. Oh, yeah, uh-huh.
So how would this firm have issued this much in securities if they're doing an initial offering? Their stock has never been issued.
Oh, yeah. Let's hear it.
Their stock has never been issued on the public stock market, so how would their stock have value?
That is a very astute point and a critical detail.
You're asking if they're doing an initial public offering or IPO, how can they already be a seasoned issuer?
Exactly. The key here is to distinguish between different types of offerings.
A company may be doing a new initial offering of a new class of security.
For example, they might be issuing new bonds or debt securities for the first time in a while.
But the company itself, the corporation, has already been publicly traded.
So a WKSI isn't necessarily a brand new company doing its first ever public stock sale.
They are an established public company that's now issuing more or different securities.
That's how they've already hit that $700 million outstanding stock valuation threshold.
That outstanding stock value comes from the existing shares already trading on the market.
Because they are already well known and highly scrutinized by the market, the SEC assumes the public already.
Oh yeah, let's hear it.
And what is a safe harbor and how do you bypass full registration via safe harbor?
That is a phenomenal question, and it actually jumps us forward into the 1934 Act, which is great.
Okay, let's unpack this concept of a safe harbor immediately.
A safe harbor is a protective provision within the law that shields companies from liability in certain situations.
Specifically, you're referring to the one created by the Private Securities Litigation Reform Act of 1995, or PSLRA.
Yes, the PSLRA provides a safe harbor for companies making forward-looking statements.
Okay, what is a forward-looking statement? Is that just saying we expect to grow by 10% next year?
Precisely. It's any statement about future projections, plans, or financial performance.
The company's essentially trying to predict the future for investors.
Right. And without this safe harbor, if those predictions fell short, the company could immediately be sued for securities fraud.
That would really stifle open communication with investors.
It would. So the safe harbor is a shield, but there's a huge condition.
What's the catch?
To qualify, the company must include meaningful cautionary statements with the forward-looking statement.
I see. So they have to issue a warning with the prediction.
Exactly. They have to identify important factors that could cause the actual result to differ materially from the projection.
It's the legal version of this is not guaranteed, and here's a list of things that could go wrong.
It gives them a layer of protection against civil lawsuits, but only if they are transparent about the risks.
It encourages companies to be optimistic, but also realistic and honest about the potential pitfalls.
It's a key piece of the regulatory structure that governs post-IPO communication.
So now we've transitioned nicely from the WKSI's registration shortcut to this. Oh, yeah. Go on.
Can you just explain to me what that is, the safe harbor?
Okay, let's nail down the definition one more time because it is crucial.
Absolutely. Think of a safe harbor, in legal terms, as a haven.
Yeah, a space in the hole where a company is protected from liability.
In this context, it specifically refers to the shield created by the Private Securities Litigation Reform Act.
And it shields companies from being sued if their future predictions don't come true.
Right, as long as those predictions, the forward-looking statements, come with clear warnings.
They have to include those.
Hey, yeah, what's up?
And then in the exchange, in the Securities Exchange Act of 1934, it's just a, like, for example, 10K.
Oh, back to our listener. What's up?
The 10K and the 10Q, in regards to
Oh, go for it.
filing financial documents.
That's a great transition back to the 1934 Act and corporate reporting.
You are focusing on the continuous disclosure requirement.
That's the key difference between the 1933 and 1934 Acts.
The 1933 Act was a one-time thing, the initial offering.
The 1934 Act requires continuous periodic disclosures from publicly.
Oh, go for it.
What is a Section 12 companies?
That is a critical clarifying question. We should absolutely define that now.
Okay, let's unpack this. A Section 12 company is the term used to describe the specific publicly held corporations that the 1934 Act governs.
And the criteria are very straightforward.
To be considered a Section 12 company, the corporation must have two things:
Assets in excess of $10 million.
and 500 or more shareholders. Ah, yeah, uh-huh.
So then, if it's not a Section 12 company, do they have to file an annual 10K and 10Q?
That is a very specific and insightful question.
Okay, let's unpack this important distinction.
Generally speaking, the continuous reporting requirements, including the annual 10K, are mandated only for Section 12 companies.
That's the whole point of the $10 million in assets and 5.
Yep, go on.
Are all companies filed with SEC?
Oh, yeah. Uh-huh.
Filed with SEC Section 12,
Oh, yeah, uh-huh.
or can they not be Section 12 and still have an initial offering?
That is a brilliant question that gets to the heart of the two acts.
Okay, let's unpack this. The answer is absolutely yes.
A company can definitely make an initial public offering without becoming a Section 12 company.
Why? Because the 1933 Act governs the initial offering.
And the Oh, yeah, uh-huh.
So then, if they're not Section 12, they don't have to file a 10Q or 10K. Then how would they know, like, what the hell they're doing financially?
That's a great distillation of the situation.
You've hit on the precise legal loophole that exists.
If they aren't a Section 12 company, They do not have the continuous filing requirements.
They meet the initial disclosure of the 1933 Act.
But they avoid the constant filing of the 1934 Act, including the 10Q and 10K.
This is done intentionally, though.
It keeps the regulatory
Oh yeah, let's hear it.
So then what's section 10b-5 of the mechanics of insider trading?
It keeps the regulatory burden off of smaller, newer, or private companies.
You are absolutely on the right track, and Section 10b-5 is critical.
Okay, let's unpack this. We were planning to focus on that next, so let's jump right into it.
Section 10b-5 is the anti-fraud provision under the 1934 Securities Exchange Act.
Even if a company avoids being a Section 12 company and the continuous 10K and 10Q filings,
They absolutely cannot escape Section 10b-5.
this rule prohibits the commission of fraud in connection with the purchase or sale of any security.
It's the ultimate safety net the SEC uses to stop misconduct in the market.
And what's fascinating is that it covers almost all types of securities.
It doesn't even matter if they were registered under the 1933 Act or not.
That means that even if a private company is flying under the radar, they still can't lie.
Precisely. If they commit fraud, whether it's through a material misrepresentation or omission, 10b-5 applies.
Oh yeah, let's hear it.
So the Sarbanes-Oxley, the SOX,
Oh yeah, go on.
the Corporate Responsibilities Act, the Sarbanes-Oxley Act, 2002, is
Hey, yeah, what's up?
the penalty criminal?
Oh, back to our listener. What's up?
Is the penalty criminal and federally criminal, and also
Oh, go for it.
is the penalty criminal?
That is a very sharp observation.
You're jumping ahead to the penalties for misconduct.
And you've connected 10b-5 to the Sarbanes-Oxley Act, which is great.
Okay, let's unpack this. The answer is absolutely yes.
Violations of the 1934 Act, which includes 10b-5, can absolutely lead to severe criminal penalties.
This requires scienter, meaning the intent to defraud and knowledge of your misconduct.
An individual can be fined up to $5 million and imprisoned up to 20 years.
For corporations, the fine can reach up to $25 million.
And as you noted, the Sarbanes-Oxley Act of 2002 amplified those consequences.
Oh, go for it.
So, for example, the CEO or the CFO, if they filed like a 10K that was like inaccurate on purpose, like some kind of fraud, they would be criminally charged by the SEC.
Officer willfully violates the act, they can be imprisoned for up to 25 years.
That is precisely what the Sarbanes-Oxley Act was designed to prevent.
Ah, yeah, uh-huh.
Is it 25 years or is it 20 years? What's the maximum penalty?
That is a critical clarification to make.
You are right to focus on those top line numbers.
The penalty depends on which specific section of the law is violated.
For general fraud violations under the 1934 Act, the maximum imprisonment for an individual is 20 years.
However, the Sarbanes-Oxley Act, which you correctly mentioned, increases that severity.
If a corporate officer commits a willful violation of the Act, they can be imprisoned for up to 25 years.
Yep, go on.
So then Section 10b-5 is part of the Securities Exchange Act of 1934.
Absolutely, you've nailed it.
That is precisely correct.
Section 10b-5 is the crucial anti-fraud provision,
It is part of the Securities Exchange Act of 1934.
and that's what makes it so powerful.
Because